the commentator too deserves applause. We proved that. So we are doing well on time, and we have about 40 minutes for a discussion. But before we step into the public discussion, we should give the panelists an opportunity to respond to the comments that Jiří provided. I also wanted to ask, I'm not quite sure how to formally deal with a written presentation, but if Hans Püschel wanted to comment, correct, or add a few words to the summary of your arguments and the commentary on it that Jiří provided, you would certainly have the floor and would be welcome to do so. Why don't we hear from the other panelists and then give the word to Hans Püschel. And I wanted to say just one word before we do so. I commented earlier that I found it so fascinating attending this conference that it's not just an academic processing of the past. It's not just academic dealing with the processing of the past. It is processing of the past itself, and so many who are here are affected directly in their biographies by the past, and this is a spirit that I appreciate and that humbles me. And I wanted to say just that among those who present here today, for example, Hans Püschel is currently an advisor for the victims of political violence in Potsdam, so there is a practical engagement, and his academic and professional biography has led him to Tbilisi, to Vilnius, to Frankfurt an der Oder. And I also should have mentioned earlier, I apologize for omitting that, Alexandra Glishtinska has, in addition to her academic work, a profound, how shall I put it, policy engagements and movement engagements. Among other things, I'll mention just this one. She's the vice president of the Open Republic Association Against Anti-Semitism and Xenophobia, which is an important Polish NGO, and she has, on related issues, also written reports for the Polish Parliament. So I should not leave out this sort of information, but I will open things up now and ask the panelists to respond to the commentary. Shall we maybe proceed in the order in which you presented your papers? Okay, Alexandra, you would be first then.
Thank you, and thank you very much for the comments. And I agree that there is this one crucial question: are we not demanding and expecting too much from the judges of the European Court of Human Rights? I think it's true, and this is really difficult to ask them to switch from their role as legal judges to moral judges. But and you quoted me quoting Judge Zupancic. Are we here to correct the historical wrongs? He also says historical and collective aspects of the situation are beyond the scope of our jurisdiction here. So it's true, and I would agree with him. The problem is that sometimes, and in this particular case, in cases concerning the Nazi past, the judges in the court very often assessed and analyzed those historical and collective aspects of the situation, when dealing with communism and Stalinism, the judges very often claim that this is not the role of ours to engage into historical debates, and we should just stay out of the historical controversies of particular states and politics and social discussions in this particular in a particular state. So for me, this is like the crucial problem when the judges say they want to be involved, and when they just don't want to engage in the discussion. And I think that the Holocaust denial cases is a good example of situation when the Strasbourg judges are really willing to decide on or to be a part of the historical discussion, and in a way it is easier for them to formulate some moral judgments or partly moral judgments concerning this part of history, and trying to avoid doing the same in case of communism and Stalinism. And I would also like to refer briefly to this, what you said about the thin line between words and deeds, and the moment or the place where we should pose the border between for penalization of words and deeds. And I think that here the Rwandan example is of particular importance, when innocent songs, which seemed at the beginning, then turn out to be one of the elements which caused the genocide and mass atrocities. So I think that very famous Polish historian Professor Jedlicki once said that hate is like a virus which can stay dormant for a long period of time and then just once wake up and become kind of form of mass atrocity and crime. So we must be very careful, and this is one of the explanations to penalize some words also, not only deeds. Thank you.
Thanks, Sherry. Bureaucracy is your issue, and Ron Herschel's important work on the subject, which, as you observe, concerns an objection to the notion that judges should turn themselves into moral arbitrators or arbitrators, resolving issues and disputes on general ethical bases, either outside the law or even arguably within the law in terms of general principles that it embodies, perhaps implicitly. I don't think what I'm defending is not bureaucracy, because I'm arguing that what the Inter-American Court of Human Rights has done is defensible, not in terms of a theory of transitional justice, which would entail a kind of bureaucracy, because it's prospective primarily in its focus, but rather a very, very conservative view of the judicial role. The very opposite of what Ron Herschel has in mind when he speaks of bureaucracy. The conservative view of the judicial role in civil cases is to put people back into their rightful position, where they would have been but for the wrong. And my argument is that all of these seemingly radical measures that we all invoke as very innovative and path-breaking, in fact, properly understood in terms of traditional legal reasoning, fit very squarely within the notion of a rightful position, which is the standard conservative function of what judges should be doing.
Thank you, Mark. And Christina, please.
Thank you very much for this lively and provocative comments. I might disagree on Said's methodology, but however, it's an important point to think about ideas and material conditions together. And if you just look at this one law journal, which doesn't seem very material, but the fact that people lost their jobs means then very unlikely to want to publish or be too able to publish, right? I do think that thinking comes before doing in many cases. So we have to think about what constitutes the possibility of the Drang nach Osten, of thinking of people living further east as cheap labor, as not having a legitimate voice, right? And that is also important. So, I mean, once these East German professors have been basically taken out of their jobs, their voice also disappears. And one thing I should add is, I'm not saying there's only this grand conspiracy of West Germans just squashing everything from the East. What happened in the journal is, so you have the censors and the people who've been censored writing in the same journal. And what happens is that the censors are the first to turn around completely. In German, there's the term Wendehals, for a bird that turns its head 180 degrees, like woo. And suddenly they write the most mainstream bourgeois liberal rule of law stuff that ever existed on the planet. And then the former dissidents have no way, wait, what just happened? Because they, for years, tried to prove that they're really good Marxists, and you can still have a rule of law and have some Marxism in there, and that's really exciting. And suddenly that nobody cared. And also they lost their jobs and had to reapply. So it's really an important interplay between ideas and senses of entitlement and material conditions. But I think we have to look at both and not just see everything as a cheap ploy for natural or human resources. And even then think about why the East, right? And we know also from World War II that the violence in the East and the West was markedly different, and then the rates of death of civilians and prisoners were markedly different. And that's a legacy of that, imagining the East as this kind of space. And for me, Orientalism just worked. It sounds very pragmatic and crude, but it just helped me to explain lots of things, what happened. I think Radbuch's formula is often cited, not quite applied, because just citing Radbuch, at least in the German context, gives you this air of moral superiority and moral depth. Here's Radbuch, and probably in other contexts, because citing German legal theorists just by itself does the same thing. And Radbruch has said the following thing, and therefore we do whatever. So I can really use for all kinds of purposes. As Devin Pennis has argued provocatively, by adopting a very new and very restrictive and very anti-prosecution version of the rule of law, West German, not very post-Nazi jurists actually involuntarily became liberals. Because once you say for yourself, no, you can't prosecute me because it was the law, you have to grant this to other people too. So his argument is that they actually invented a new rule of law as being ancient, that protected themselves, which then also led to much more, entrenched, very formalistic rule of law. East Germans certainly had responses to telephone justice. However, those responses, and that's part of the story of Neue Justiz, were not really heard because those people were too busy reapplying for jobs, right? So not only were they not qualified because they were not lawyers or not law professors or too busy collecting unemployment insurance, but also, so they were disqualified in terms of the formal qualifications, but also because they plainly had other things to do, and in many cases selling insurances and all these exciting things that you need to do to pay your bills. So thank you very much.
Thank you, Christina. So I see that Hannah already passed the microphone on to Hannes Büschel, who provided a written contribution. Would you like to comment on Jirgi's comments to your paper?
Hello? Okay, no. Okay, so thanks for your remarks. I have to say in my paper I concentrated on the question of denial. I planned to write something about the question of outlawing public use of symbols. Due to the limitations of the length of the paper, I decided not to do so, but I'm happy that Alexandra did so and opened the possibility for discussion on that. What I want to mention in this context is, especially if we speak about transitional justice, it's a question of laws which outlaw certain sides on history. We have a wave, an international wave with these laws, from France to Russia, from Germany to via Turkey to Cambodia. Everywhere we see laws which penalizes different sides on history. So some people claim that it should be illegal to deny the Armenian genocide. We have the laws against Holocaust denial. We have laws against denial of communist crimes, and so on and so on. I see the problem that with these laws we close doors for open discussions where we need open discussions, where we need discussions about causalities, about historical relations between nations, between perpetrators and victims. And these laws are very retrospective. So the laws against Holocaust denial in Germany were not created in 1949. They were created since the 1980s. So the Austrian example is a bit different. Yeah? The laws against denial of the Armenian genocide are created now, so nearly 100 years after, and so on and so on. And I think they serve more for fixing national identities and hindering discussions than for open discussions which are necessary for democratic procedures.
Thank you, Hannes Büschel. I would like now to open the floor to comments from the audience, and we'll listen to three, I suggest, and then the panelists can respond as they see fit. And Adam Czarnota was the first to raise his hand.
Thank you very much. I've got a comment questions actually to the two speakers. I mean to Alexandra and Christiane. And we'll start maybe with Christiane and then we'll move to Alexandra, okay? The first is my interpretation of the Radbruch formula was always such way that, well, it was really that that legal positivism made German lawyers defenseless. You claim here that was a foundation lie because they were not legal positivists. It means Nazi lawyers, they were not legal positivists. It seems to be not necessarily. If we accept the interpretation of Nazi state as a dual state, which was a sort of the standard type of interpretation, what that means, only in the situation of exception, there was a moving out from the normal literal application of the black letter law. And the normal majority, statistically speaking, the 99% of the legal relations as such, there was application of the positivist, in the positivistic way, a normal positive black letter law. So it seems to me that Radbruch somehow, possibly, was right. It means it was made defenseless because there was no argument to use law in a totally different way. We have to probably look at the type of legal education which existed in Germany, in Weimar Germany, and how this, what was the way of preparing lawyers and judges. So it's a one part. Now to Alexander. The question was here asked by Jiří, didn't we expect too much? I think that not at all. It means, why not at all? Well, let's make a sort of the detour, right? It means, Neil McCormick, in one of his articles, claimed basically that we could look at law as based on some sort of the historical narrative, which is narrative which provides legitimacy for the existing legal system. And then what this narrative do also is providing the legal system also with normative cohesion. That was his claim. And I agree actually with Neil McCormick. Now what we observe, and you put it nicely here in your paper, are the two different narratives as such. It means competing to some way, right? It means accepted by whom? By the European Court of Human Rights. And then I want to stress that I present here is Wojciech Sadurski, who in his book claimed actually that constitutionalization of Europe is mainly done by the European Court of Human Rights. If the necessary, it seems to me, if we accept now, bring in now Neil McCormick, so necessary precondition for the constitutionalization of Europe is maybe not total unification of narratives, but at least harmonization of narratives, which means create such space in which there will be no competition between them. And that was, it seems to me, partly subject of Elazar Bankar talk here, right? His keynote lecture. What he claimed there was organize some public space for not unification, but for the exchange of information which possibly will make conflicting narratives less conflicting. So my question to you is, as a lawyer and involved in the, as was told here, in the policies, right? It means how to do this? Do you see some institutional design maybe? What sort of approach is possible to take? Thank you.
Yes, Cosmin, please, you're next.
Okay. Thank you. Thank you very much for your presentation first and for the whole comments. And I have a series of comments and probably two questions, one for Alexandra and one for Christiane. First of all, I'm picking on a bit on Adam's comments, and I'm asking myself from a Luhmannian perspective, whether isn't it structurally, to some extent, the law cannot really integrate historical discourse, because for the time being, well, it came to integrate the historical narrative of the Holocaust because there has been a long of historian work on it. And on the other hand, that there has been a lot of legal, judicial activity on the question of Holocaust. We had the Nuremberg trial, which has been this kind of, let's say, landmark case. And then I'm asking myself whether it wouldn't be possible to some extent to find a way in which one could link the memory of the Holocaust to communism. To link somehow, not in the totalitarian classical paradigm, because for historians, totalitarianism is no longer a paradigm. They have moved for a long time beyond totalitarianism. But we could probably find ways in which we can trace continuities somehow, and this might enable this raise of awareness, which might turn into some equality of legal treatment. Still, I still consider that the two dimensions, well, communism and Nazism, they should still be differentiated somehow. For Christian, there is an expression in German. It's I'm not sure whether it's very, but it's very much whether I'm pronouncing it well. It's called "Auf der Teufel in der Walachei," and it's very much related to this representation of Walachei, Romania, Wallachia, the devil in at the devil in Wallachia, and it's very much related to this representation of the East as a space of lawlessness. And here I think maybe closer to Eastern European context, Larry Wolff's book on the invention of Eastern Europe might be more useful than Said's Orientalism, because there you can trace back the whole this idea of a lawless practice, a space which to some extent might be related also to the concept of Volklosser Raum. Later on, this idea of a space which is outside the law somehow, and it's so I'm asking myself to which extent this relation between Western Germany and Eastern Germany can be somehow transposed at the level of Europe, between Western Europe and what they conceived as being Eastern Europe, and to which extent this idea of lawless area existent in countries like Romania and so on. It's not here Radbruch's come into place once again, because to which extent is not this kind of a sort of a myth, looking at this idea that during communism or Nazism they have been pure lawlessness. Well, sorry.
The next hand was here, the gentleman in the front row.
Ja komentarz prasowy. Nawiązując do wystąpienia pana profesora Marka Aussila, który na pewno zna taką książkę Era Zawirowań. Ta era zawirowań daje nam jak gdyby taki obraz współczesności dla przyszłości. I ja mam w kontekście wypowiedzi pani Aleksandry taki komentarz. Mianowicie, dzisiaj kwestia komunizmu, faszyzmu, nazizmu, stalinizmu jest wciąż otwarta. Ale chciałem odnieść uwagę pani do takiej książki, ja w tej chwili zapomniałem autora, ale ukazała się 2 lata temu, Skażenie Unii Europejskiej. Jest taki tytuł. I na okładce tej książki, Skażenie Unii Europejskiej, z jednej strony jest swastyka, a z drugiej gwiazda oczywiście ZSRR. I są uwagi dotyczące 2 pojęć. Unii Europejskiej i euroazjatyzmu. I we wnioskach mówi się o tym, że temu imperialnemu i niemieckiemu Drang nach Osten i Drang nach Westen powinien towarzyszyć przede wszystkim rozsądek i umiar w zakresie partnerstwa wschodniego. Ono dzisiaj tam w Wilnie obraduje. Chciałem prosić panią Aleksandrę o komentarz na ten temat. Natomiast Jerzego Prybana, panie profesorze, wciąż my pamiętamy bardzo dobrze, kiedy Polska czeka na swego Dubčeka. I jednak ten rok 1968, ja chciałbym prosić pana, czy jest w stanie dzisiaj odrębnie Czesi, odrębnie Słowacy spojrzeć na ten rok. Cała Polska czeka na swojego Dubčeka. Podobnie zresztą, panie profesorze, skoro pan jest rzeczywiście filozofem prawa, to trzeba byłoby też poszukać jakiejś rozsądnej odpowiedzi. Ja to zapisałam po pana wystąpieniu, panie profesorze Jerzy. Co karać, kogo i za co? To jest właśnie zasadnicze pytanie. Co karać, kogo i za co? I chciałbym prosić pana o komentarz prasowy właśnie, bo ja jestem dziennikarzem i z tej konferencji 3-dniowej chcę napisać do Polityki taki dłuższy tekst, polemiczny zresztą. Ja w Polskim Radiu w okresie Dank und Sturm, czyli 80-81, prowadziłem w Polskim Radiu taki cykl audycji, wersje i kontrowersje. One były nadawane w programie drugim i w programie pierwszym Polskiego Radia w tym bardzo trudnym okresie, ale chciałbym jednocześnie prosić pana o komentarz dotyczący rozliczeń 56 roku na Węgrzech i 68 w Czechach. Dziękuję.
These were three sets of comments and questions, and I would like the panelists to have an opportunity to respond in whichever order you would prefer. Mark, would you like to start?
You referred to a book that I'm, alas, unfamiliar with, so I can't really respond to that, but thank you for your thoughts.
Closer to me. Yeah, now it works. Thank you. So I will try to answer both of your questions at the same time to Professor Czarnota and to Kosmins. How to achieve harmonization of conflicting narratives? Is there any more difficult question I could get? Like, it seems impossible to find the good answer. How to do this? And my first thought was, should we do this through law or through education more? And as as Professor mentioned, as I'm engaged in an NGO activities of Open Republic Association, and I very often deal with court proceedings and court cases concerning anti-Semitic hate speech and hate crimes. And I deal with judges, I deal with prosecutors a lot, then I must say that I lose my hope, I'm losing my hope as to the impact of law that may have on the situation in the regard of anti-Semitic hate speech, this particular, but also racist, xenophobic hate speech and hate crimes. So I think that law cannot not fully integrate historical. Now moving to the main question, main topic, to the historical discourse, because those discourses and those narratives are so divided still. That it seems impossible really to find like the one narrative which could be accepted by everyone. I think when it comes to Holocaust, there is the field of understanding and common understanding of this what happened and of how we should deal with it, although, as also said, there are big controversies concerning penalization of Holocaust denial. And for example, this is an example where the disputes over if to penalize both Holocaust denial and, for example, Armenian genocide denial these disputes led to even a greater division between conflicting parties and different narratives. Although this is my personal opinion, I think that in case of Holocaust denial, the most important prerequisite we should take into account is the modern dimension of Holocaust denial, which can be seen as a form of anti-Semitism spread all over the world very intensively, and in particular in Arab world today, but also in states like Japan, which is not maybe widely known, but in Japan Holocaust denial is almost a kind of a fact. So, my answer would be that finding ways to harmonize those conflicting narratives, it's still a task which we should all contribute to finding the solution to this difficult question. Skażenie Unii Europejskiej, nie miałam okazji zapoznać się z tą książką, nie słyszałam o niej, natomiast jeśli chodzi o rozsądek i umiar w polityce, to zawsze, myślę, jest bardzo przydatny i kluczowy, a jeśli chodzi o Partnerstwo Wschodnie, to myślę, że pomimo tego nieszczęsnego czy nie rozwijającego się pomyślnie toku wydarzeń związanych z Ukrainą, myślę, że same partnerstwo jako koncepcja realizowana już od kilku lat jest bardzo pożyteczna i na pewno warta dalszych wysiłków. Dziękuję.
A word about timing. We have 7 minutes left, and Christina and Jiří still wanted to comment on the comments, and then I have 2 more signs of hand, if I did not overlook 3. So it will be those 3, and then there will be another chance to comment. We don't want to drag this too much into the lunch break, because we are not just scholars, but human beings with organisms, and we need to function. So, Christina.
All right. Hello? Yes. I think they're doing magic in the back, sometimes. Okay, thank you very much for your questions. According to their own self-description, Nazi lawyers were not legal positivists. In fact, they've been describing legal positivism as Jewish and as degrading and contaminating German law. So yeah, we can find a way of making them look like positivists, but it really does not correspond to any meanings of legal positivism that were around in 1933 or 1946. In particular, positivism was connected precisely to people like Radbach and Kelsen. So they were the ciphers, the symbols of positivism, and yeah, they were both dismissed, and Kelsen was kicked out of the country, and so on. I think there are lots of books in this coming more about taking stock of these more subtle hierarchies that are not as stark as European-African relationships and imaginaries, right? So that the fact that not everything, the post-colonial theory is not just good for talking about outright conquest and genocide, as was the mode of dealing with Africa and Latin America, but also for other more subtle hierarchies, and also I know about the Balkans, there's a bunch of really good books that help us. And the challenge is to then bring question of law in there and not just stay on the level of culture and politics in general. So there's also some good stuff about East Germany that makes a claim and then backtracks and apologizes for making the claim, because clearly that can't be the case, that it was that we have colonial imaginaries there. And I think in a way, it's a question to all of you, how much what I've been trying to show about West Germany, East Germany applies to Europe at large. Certainly, listening to Alexandra's presentation, it seems that for the European Court of Human Rights, the Holocaust is our history, and Stalinism is other people's past. So in a way, we're not really responsible. It seems to me that this is clearly part of the dynamic, but you know the documents better, so I don't want to interpret your findings. And certainly, if you look at the process of EU accession, I mean, look at how many thousands of pages of laws, and it was all about changing laws, right? And no chance for the accession states to say, actually, can we keep our stuff and you change? And in this case, it was literally the same mode of joining as East Germany had with West Germany. So yes, we're still doing it. It's not good. maybe we can rethink some things.
Push. Listening to Christiane, it occurred to me that on your conceptualizations of positivism and arbitrariness, a work by distinguished legal scholar and sociologist Adam Podgoretsky might be helpful, who said that he used the Kelsenian analysis and saying, well, the communist law has classness as the basic norm. Maybe the basic norm formula would be helpful here. But going back, I really liked what this dynamics between Adam and Kozmin's comments. When Kozmin says, law cannot integrate historical narrative, this is exactly what I would agree. I would sign it immediately. And, but I agree with Adam's and Wojciech's notion of, yes, if there is to be European constitutionalism, it has to happen through these institutions as well. And it's fascinating what we heard from Alexandra, that there is incongruence. There is almost like two parallel stories, but we shouldn't. It is easy to explain because the Holocaust is a birthmark of the European Court of Human Rights. After such a horrible horror of Second World War and Holocaust, you have this court stepping in and saying, and now we're gonna do things differently. So yeah, it may be explained through historical method, but we shouldn't expect European Court of Human Rights to constitute our collective memories. We have to do it ourselves and beyond the court. Now, yes, Waiting for Dubček. It would be a nice play. Absurd, and it's though, yeah, unlike Godot, we saw Dubček, and I was just 1 year old when, and I have a picture with Dubček's picture, and behind me, just eating my custard, and so it is a personal memory. Talking of personal histories and personal memories. Who should be punished for what? I'm probably much more skeptical than Mark about the judiciary and justice, because I think if we say this is what the judges should always do and do, in transitional justice, there's always a risk. In America and in American legal history, yes, judges judge and politicians listen. And in transitional justice, very often when judges judge in a too activist way, politicians will stop listening. There's a very, very thin line, and we have to balance it well. But, like Mark, I believe in certain minimum principles of criminal justice, and so I believe that for crimes which can be punished on the principles of criminal law, which are punishable, should be prosecuted and should be punished, because there nobody stands above the law. So this is all those crimes that can be punished. I even believe in the principle, and it's a very, very thin line here. I believe that in the worst crimes like murder and genocide, of course, you have no period of limitations for war crimes, for crimes against humanity. But even for crimes like murder, and now I'm saying something I probably, will regret. I believe for crimes like political murders, period of limitation should be extended, like in Germany they did. I think it's perfectly justifiable. However, I also believe that if part of political transition and transitional justice is we grant impunity, like in for instance, in South Africa, you have to stick to it as if it were a strict legal principle, not just politically negotiate principle, which you can retract the moment you consolidate your democracy. You have to play by rules. Yes.
Thank you all. Our time is formally up, but we have 3 voices, and I would like to hear them. And I would ask you to be as concise as you can possibly be, and have a final word for each panelist, also as concise as can possibly be. I think you were the next.
Thank you. Wojciech Sadurski is my name. Okay, so I just have a comment/question to Alexandra and to Christian, but you are both welcome to take them only as comments rather than demanding your responses. So first to Alexandra. Okay, so you discern these double standards in the attitude of the European Court of Human Rights towards these 2 different pasts, towards Stalinism and towards Nazism. But what I would like to suggest is that there may be a much simpler, maybe almost pedestrian, legal, formal explanation for these double standards, which has nothing to do with the nature of European memories, but much more with the institutional character of the European Court of Human Rights. And that is that the European Court of Human Rights has been much more deferential towards West European countries and was much more eager to accept laws under its own so-called margin of appreciation deference standards coming from consolidated democracy of Western Europe than towards Central and Eastern Europe, which was seen to some extent rightly as very immature in terms of its human rights approach. So the examples which you give, those examples when the European Court of Human Rights was eager to accept militant democracy under the European Charter or European Convention, came from countries like Germany and Austria, and these were usually beneficiaries of large deference from the European Court. While the countries where militant democracy, sort of hostility towards communist symbols like your examples of Romania and Hungary, came from the countries which became judged much more harshly by the European Court of Human Rights. So in this sense, I think we need to introduce this type of variable about the, if you like, jurisdictional and institutional approach of the European Court of Human Rights, and therefore I would warn against taking Strasbourg Court as too much of an insight into what's going on in the European memories. And a comment to Christian, if I may. Briefly, what were the fundamental asymmetries in the case of Radbruch's Germany and post-reunification Germany regarding the rule of law? And I would say that, maybe you've mentioned that, but let me offer the following simplifying hypothesis. In the case of Radbruch, or in the case of the fall of Third Reich, the situation was more difficult than in the case of the attitudes towards DDR, because the fundamental problem with the Third Reich's law was that it was fundamentally evil law. Evil on its face, so to speak. Remember that one of the famous cases discussed in Radbruch and then picked up by H.L.A. Hart was the grudge informer case about the woman who informed about her husband criticizing German authorities, which was sort of the law which was on its face evil. So the problem was not so much with arbitrary application of the law, but with the evil of the law itself. In the case of DDR, the situation from the point of view of the rule of law was fundamentally different. I mean, on its face, it wasn't a fundamentally unjust, evil, wicked law. It's that the law did not matter much, that the law wasn't applied, that the law was fundamentally subject to purely political arbitrary decision. Now, from the point of view of the ideal of the rule of law, the second case is much easier than the first case, because if the law is fundamentally fine, but the judges and the authorities do not play by its own standards, then for the rule of law it's an easy case. It's much harder case when the law seems to be applied correctly, but it's fundamentally evil in itself, because we must somehow go into the questions of natural natural law, etc., which are much more complex. So here is maybe fundamental asymmetry between the two cases.
Thank you. The next question is over there by Saigon Kökarixel.
It's a short question, actually. And then I think you usually kind of brought it up, and I would like you to reflect on that too, the function of human rights here. We talked a lot about the courts, but also and the rule of law, and I would like to hear more about this, the political and moral function of human rights. For instance, yesterday we talked about how transitional justice is always already political, or is always can be, you know, politically instrumentalized, and I'm wondering how you see the practice of human rights in the courts, in writing history of violence and so on and so forth.
Thank you. And the last question will be from Hannes Büschel, and then a brief comment by the panelists.
It's not a question, it's more a comment to Alexandra and Christiane. I agree completely with the idea that there's too little knowledge about Eastern or Central European history in Western Europe. That's true. That's a fact. Yeah, people there know too little about what happened here. But vice versa, the same is true. The talk about the different, or about concurrent, about the narratives, about the Holocaust narrative versus the Stalinist narrative, in case of the European Court of Human Rights, blurs or simplifies and blurs what happened in reality. If we go, like you have done, to the decisions by the European Court of Justice, we see that the European Court don't consider every kind of communist activity as totalitarian. That's the point. If we see that, everything else seems much less arbitrary than it would if we don't have this precondition. This differentiation within the communist activities by the European Court of Human Rights, in my opinion, is not a result of being stuck to a Western European Holocaust narrative. But within that, we find preserved a different historical experience on communist activities, especially of France and Italy, where the communist parties, after the important role in the anti-Nazi resistance between 1941 and 1944-45, played an important role in reconstructing parliamentary democracy, writing constitutions, and in the crisis at the end of the 1960s, defended the parliamentary democracies against the left-wing radicals, which we call the student movement. So the historical compromise in Italy should be mentioned here. So that's a complete different historical experience about communist activities under the symbol of the red flag, the red star and hammer and sickle. So, and this has nothing to do in the first point with this so-called Holocaust narrative. And in my point, to explain everything with they have this narrative and we have this narratives makes things much more difficult and is wrong, in my opinion.
Thank you. I would like to give the floor to each panelist very briefly. If you could want a final comment, constrain it within 1 minute. Mark passes his time on to others. Alexander, do you have final comments? Try to be brief.
Sure. I would like to thank for both comments, and I'll be brief. I can only assure that more on double standards and different treatments, on the reasons of those double standards and different treatments. I'll elaborate in more detail on this problem in my written version of this presentation, and I definitely take into account your comments and your remarks. So thank you.
Thank you. Thank you very much. I'm not sure if 1945-6 was harder or easier than 1992. What I know is that the German judges very consciously put themselves in the shoes of reenacting 1946, which they know they got wrong. So there was a very strong sense of doing to the communists what we didn't dare to do to the Nazis, which has its own completely messed up dynamic. So maybe they didn't need Repo, but they loved him. That's what I can say. If it was easy or hard what they do, that's up to them. That's not for me to judge.
So, Simon said, and I liked Lavinia's remark yesterday. I said, I like politics because it's dirty. And it's because I'm afraid that sometimes lawyers want to purify too much. They are legal fundamentalists. And I don't mean just pure theory of law, and they believe that they can deal with the past, they can deal with history, but, I loved Hanel's comment who said, well, you cannot outlaw history, you always have to work through it. It's not just dealing, it's working through your history, through your past. History is always in the open, law always wants to close things up.
Thank you all very much. I constrained myself. I would have had some comments on this and that has been said. But that's not the role of a chair. So I thank the audience very much, and I thank the panelists. It was another fascinating session with provocative themes, and while we eat, we might be able to speak, even though our parents told us not to. Thank you very much.